Pereira. Parliament on Thursday passed amendments to the insolvency law that will help safeguard successful bidders of insolvent companies from the risk of criminal proceedings for offences committed by previous promoters. The Insolvency and Bankruptcy Code Amendment Bill 2020 was passed by voice vote in the Rajya Sabha. It was approved by the Lok Sabha on March 6th. The bill replaces an ordinance. Replying to a short debate on the bill, Finance Minister Nirmala Sitharaman said amendments are in sync with the time and also adhere to a Supreme Court order in letter and spirit. The bill seeks to remove bottlenecks and streamline the corporate insolvency resolution process. It aims to provide protection to new owners of a loan defaulter company against prosecution for misdeeds of previous owners. The latest changes pertain to various sections of the IBC as well as the introduction of a new section. On this edition of The Big Picture, we will analyze the Insolvency and Bankruptcy Code Amendment Bill 2020. Joining me on the program today are Chakshu Roy, Head of Outreach, PRS Legislative Research, A.K. Bhattacharya, Editorial Director of the Business Standard, and Subhash Chandra Pandey, Financial Advisor, Ministry of Commerce and Industry. All right, thank you to all my guests for joining me on this edition of The Big Picture. So, Chakshu, let me begin the program with you. Let's first try and analyze and figure out the new amendments to the IBC.
Frank, as your viewers might know, that the Insolvency and Bankruptcy Code was passed by Parliament in the previous Lok Sabha. The idea of the law was to ensure that companies which were in financial trouble, how they can be rescued, and if they can't be rescued, as to what is the maximum value that you can get out of these companies so that creditors can be paid. And one of the highlights of that bill was that it established a threshold on the basis of which a creditor could approach for insolvency proceedings against a company. Another amendment came in which installed home buyers in the same position as financial creditors. And this is the background in which this amendment bill has come in. What this amendment bill is now doing is that it is saying that home buyers, creditors who are home buyers, they should be 10% of the total project, or a minimum of 100 home buyers who can initiate insolvency proceedings against a particular company. So that's one of the things that is being done. The second thing that is being done is that the bill is now allowing that the insolvency professional, the people who are running the company when the company has gone into insolvency, to require suppliers of essential goods and services on the basis of which the company can function. It can these insolvency professionals can require these suppliers to continue providing services to the company so that the company can work. So these are roughly the two big changes that this bill is bringing in.
Okay, all right. So, Mr. Pandey, let's take the discussion forward now. As far as the IBC is concerned, how is it going to help as far as some of the problems that we are facing, with regards to home buyers, with regards to companies facing insolvency and so on and so forth?
Frank, let us first appreciate that through this IBC process, we are trying to use legal instruments to address problems which are essentially of a business or economic nature. And all the promoters are not crooks. Many have gone into defaults and difficulties because of other reasons or cross defaults by third parties. So there is a liquidity problem across the system, which has made even otherwise well-meaning promoters also land into difficulty. So what this new latest amendment does is balancing the requirements of the creditors, operational creditors, retail creditors, as well as the corporate debtor that is being dragged to the insolvency court. So the home buyers or operational creditors, before this amendment, even a single home buyer, a single operational creditor could approach and trigger an insolvency process, and the moment it is done, it also brings into standstill its operations. So this is that means it only aggravates the problem which the corporate debtor was facing. So this amendment does two things. One is to carry on the critical operations so that the corporate debtor survives and improves to pay off. And secondly, to create a threshold where every small operational creditor, supplier, home buyer is not able to invoke insolvency.
Okay. Okay. All right. So, Mr. Bhattacharya, as far as new promoters are concerned, let's look at a company like Jet Airways now. It's been in the news for the last one odd year. One of the biggest contentions for a new investor was they did not want to be held liable for something that happened to the company in the past. Will this amendment now address those kind of issues, and do you believe that those kind of issues need to be addressed? Because we're going to see many firms going into this process.
Well, I think you hit the nail on its head, in a sense that insolvency and bankruptcy code as a piece of legislation, it's a kind of a legislation that one has not seen in the past. It's a new experiment to address the issue of insolvency, to rescue debt which have become sticky. So therefore, what we have seen since its introduction in 2016, that we have seen many changes, and they are all welcome changes, because as the law is being implemented, you are experiencing issues, and I must say that the government has been quick in addressing those issues. So we have to see this amendment, particular amendment, in light of this experience of how the government is responding to challenges of a dynamic situation to resolve stressed asset issue. Now, the question about providing immunity to a company and its promoters who come over and take over a stressed asset was very important, because as you mentioned this company, Jet. Now, as we all know that the Jet's existing promoters are embroiled in all kind of legal complications. Now, if somebody were to make a bid for Jet Airways, now it is important that to make that insolvency resolution process succeed, that the new promoter should not be burdened with the legacy issues of that company and that promoter. So this amendment provides immunity against such legacy cases. So let us say Mr. X takes over Jet. Now Mr. X will not be held liable to address the questions of impropriety or legal malfeasance committed by the previous earlier promoters of Jet. Now there is why I say that this is an important piece of legislation is because that even while granting that immunity, there are conditions that have been introduced which are very important conditions. For example, if the new promoter of a company which has been embroiled in legal questions has any connection with the old promoter, then this amendment does not apply. In a sense, that let us say the new promoter who comes and takes over Jet, since you mentioned Jet, and the Jet's existing promoters have something to deal with in terms of legal compliance, and they have not followed that compliance. So if the old promoters are in some way related to the management of the acquiring company, then this immunity will not sing. So therefore, what I am saying is this, that this has been a well thought through process, and it will address the concerns of many stressed assets, because the large number of stressed assets are indeed in this country are embroiled in all kind of legal complications. So if you want to have a quick resolution, one thing is that you have given the empowered the resolution professionals to continue the business without any interruption. You have made sure that the license and the supply conditions that were originally with the existing company will continue to remain intact. Now that's another way of providing continuity and maintaining the attractiveness of a concern that has gone in for the insolvency resolution process. So both these measures, to my mind, will revive some sort of a credibility in the process and not turn away many acquirers. Now the net gainers of this exercise will be the creditors. Now the creditors will see some hope of getting more value for their stuck loans instead of a situation where because of this lack of immunity, they were not getting the right price. So I think it's a good move forward, and my sense is not just JET, but there are quite a few other cases where the courts and NCLT will have to come in and rule in favor of the new promoters as long as they are not related to the old management. They have not brought in anybody from the old management. So
Absolutely.
this will expedite the process of resolution, which is a good thing. And some companies actually had gone to NCLT. NCLT ruled against, and they had ruled that the enforcement directorate's cases should continue. So therefore, this will put an end to all those doubts and uncertainties.
Absolutely. All right. So, Chakshu, there was a short discussion as well on this particular amendment and the IBC in the Rajya Sabha earlier on Thursday. So, what were some of the arguments made for and against it?
Frank, Rajya Sabha, when the discussion took place, a couple of things were discussed. One of the things that some members talked about was how can resolution process be expedited. And the standing committee which looked at this particular bill also came out with a recommendation that there should be an increase in the number of benches of NCLT so that the number of cases that are before NCLT can be resolved quickly. So that was one piece of thing that was discussed. The other thing that Mr. Bhattacharya was referring to was ring fencing of resolution applicants, which he explained quite in detail. So that was another issue that came up for discussion as to what are additional safeguards that are required or are current safeguards enough. And the final thing which was discussed in the House related to MSMEs who are supplying goods and services to companies which are in insolvency proceedings. And the idea of that discussion again came from the Standing Committee's report, which recommended that supplying of goods and services when it comes to MSMEs becomes a little problematic because they have limited resources, and how should they deploy their resources should be either left to them or to market forces rather than to force them. So those are some of the things that were discussed during the debate in Rajya Sabha.
All right. So, Mr. Pandey, as far as the IBC is concerned, from 2016 to now in 2020, how has it evolved and how has it caught up with the changing times?
You see, one of the reflection of its outcome can be seen from the 1819 report of the RBI on trends and progress in banking, which brings out a very remarkable improvement that has happened in 2018-19. The gross NPA of all scheduled commercial banks have come down from 11.2% to 9.1% from 17-18 to 18-19. And IBC has played a big role in this turnaround. More than 130 cases resolved as seen from the Standing Committee report. They involve a resolution of stressed assets amounting to about 3.74 lakh crore, which were resolved at a little over 1.5 lakh crore. So the scale of resolution progress is very massive. Of course, individual cases have gone through the labyrinth of various appeals, cross appeals, interlocutory orders, and some of these issues will get closed after hopefully this new law is implemented. This law also makes another important addition to the IBC in paving the way for further resolution of financial service providers. You recall some months back the NBFCs were brought under the ambit of IBC, where the trigger was not left to individual depositors or class action suit, but to sector regulators like RBI. So, one of the new inserted section says that the process for insolvency for that will be as prescribed. So, that will be a separate process will be prescribed, and that will expedite the ongoing resolution of, say, a DHFL, ILFS, etc. So, the main concern, as we can see, is the possibility of the challenge, which we already see. Some Chakshu has mentioned in the discussion, some appeared in the dissent notes appended in the Standing Committee report. And those are concerned about how can we take away the rights of individual home buyer when he doesn't have clarity as to who else are the allottees. There is not much transparency about that. So how will he bring an individual right is converted into a class action rule? That is a difficult balancing act which the government had to do. Otherwise, it will be a no-go situation. I am aware of a big public sector company having been ordered to be liquidated, more than 1,000 crore or something, for a default triggered by a supplier for a few lakhs. And it has led to closure of factories, loss of jobs, and massive problems across 3-4 states. So, the balancing individual creditors' interest with the interest of the corporate debtor, larger public interest, this is a fine balancing act, and to that extent, I think it was called for. The carrying on the operations is also important. MSMEs not being in a position to continued supply in a defaulted company is understandable. But imagine, supposing an airline company goes in insolvency and fuel suppliers turn off the fuel taps, then whatever status it is, it will further go down the hill. So, this balance is, as I said in the beginning, we are trying to solve problems of business and economics through law, and it does not always necessarily work. First of all, between corporate debtor and creditor, there is a direct contract, but the corporate debtor faces cross defaults by third parties, with which there is no privity of contract with the applicant creditor. So, law will say, okay, we do not take cognizance of what cross default you have suffered at the hands of third party. But in terms of a business, which is very true, because I have suffered a default from my own debtor, I am forced to pass on some of the burden and pain to my creditor. So, on the whole, this is an ongoing, a series of amendments have been done to make the IBC more balanced between the interest of corporate debtors and creditors.
Absolutely, to make it more robust on the whole. Yeah, all right. So, talking about this issue of business and the economy, Mr. Bhattacharya, the IBC has been seen as a major reform. How has it helped in addressing some issues like stressed assets since 2016, of course, and also the issue of the banking sector?
Well, to my mind, that what has happened is that the overall accretion to the NPA levels has been reined in a sense that the earlier mechanism by which you could identify stressed assets because of failure of some parties, now that trend has been kept under check. As a matter of fact, there's a large number of cases that don't even go to the resolution process. The moment there is a possibility of those cases being referred to the insolvency bankruptcy courts process, the debtor and the creditor actually get together and they realize that since there is this law and the process will get triggered, therefore they immediately resolve the cases. So there's a large number of cases that are getting resolved even before they're coming before the insolvency courts. So to judge the efficacy of this law, it will be not just be important to see the actual numbers of how many cases are being resolved, how many cases have been liquidated, but it will also be important to see the large number of cases which are getting resolved even before they come to the insolvency courts. So that's number one. Number two, what these amendments do is that what Mr. Pandey was referring to is that if there is a permit, Mr. Pandey was referring to about suppliers, fuel suppliers. Now imagine the same example of what happens to an aviation company like Jet you mentioned. Now fuel supply agreement is one thing, but there's also something called a flying license. The government gives the Jet a license and permit to fly. Now the moment it gets into the insolvency process, there was this fear that it might just become a debt concern. It loses the benefit of that permit to fly. Now this amendment has made sure and clarified that permits, contracts, licenses will continue to remain active even after going to going through the insolvency process. Now, along with that, a very small change that has been made, but its impact to my mind will be huge, which is that earlier what is to happen is the moment the corporate insolvency resolution process takes effect. Now, there is a date of admitting the case, and earlier the law was that within 14 days you have to appoint a resolution professional. Now, which means the date of its admission in CIRP and the appointment of an insolvency resolution professional, there is a gap of 2 weeks. Now, in a delicate situation, the company which is stressed has been taken to the insolvency thing can just go down under in this gap of 14 days. Now, what this amendment has done is make sure that the date of admission of a company, stressed company, under CIRP, which is Corporate Insolvency Resolution Process, will take effect only when a resolution professional has been appointed. So, what you are doing is this, you are reducing those 2 weeks of uncertainty of we do not know what will happen, who will stop doing things, and nobody will be able to take any preventive or corrective action. So, I think this law, as I said in the beginning, addresses many of the weaknesses, the gaps which surfaced when the law was being implemented. And as I said, this is a new law in this country, and the government, I must say, has learned on the go.
Right.
And it has not lost much time in learning and implementing those changes.
Sure. Okay. Time now to get closing comments from all my panelists for the best way forward. Starting first with you, Chakshu.
Frank, I'm going to try and get what Mr. Bhattacharya said and what Mr. Pandit said together. Both of them made some very important points. He talked about the fact as to we are trying to solve problems of business and economics through law. And Mr. Bhattacharya is also talking about, incentives to ensure that, creditors and debtors get together. Now, when we are trying to do these things, these are choppy waters, right? These require constant monitoring of, what is the case law, what is the kind of numbers that are coming out of insolvency proceedings. That should then inform the legislative process. So, I think what is required is a constant monitoring of the resolution field as it happens right now, how it is playing out, and then that should feed back into the legislative process to say, oh, what, do I need to tighten regulation? Do I need a change in the law? Do I need to get, more active on the legislative front? Or do I need to get a more liberal in terms of, changing my rules? So, constant monitoring about how the field is playing out is really, really important for this law to go forward.
Okay, all right, Mr. Pandey.
I would have one particular suggestion about, because as I said, the business and economics problem, that insolvency resolution professional should supersedes the existing board without necessarily having a equally competent board to assist it. So, possibly one future forward could be to see that especially in case of large corporate debtors, during this interim period, it is entrusted to a competent board of directors, which by way of some sort of a adoption.
Right.
So that would go a long way. Earlier, it used to be taking over management and appointing, which is what is happening in case of bank. That is not so much happening so in manufacturing companies. It is a single professional, and that is which is a somewhat required action.
Okay, all right. And Mr. Bhattacharya, close the show for us.
My observation, in addition to what Mr. Roy and Mr. Pandey said, will be that we must be little generous and understanding in evaluating the efficacy of a law like this at a time when the economy is going through stress times itself. Now, at a time when the economy's growth, whatever you may say globally, coronavirus impact, growth being impacted, variety of factors. So, my sense is a law of this nature will also go through a period of turmoil. And so, to expect that this law will immediately bring about great benefits, I think would be a little unfair on the law. So, therefore, we must, like all laws, the efficacy of the law at a time when there is economic distress should be judged from that perspective also, and that, to my mind, will lead to a fairer assessment and corrective actions to be taken.